There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
All right, folks, buckle up because today's case is a train wreck from start to finish. We've got Ashley Clark, a woman already on probation for endangering a child, and instead of showing up ready to own her mistakes, she decides she's going to outsmart the system. How? By firing her attorney, the one person who could have actually helped her, and defending herself. Yes, you heard that right. Now, if you're sitting there thinking, well, maybe she's sharp enough to handle it, trust me,
This comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm gonna make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want to contest the hearing?
I'm gonna contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
No.
is not. Within minutes of the judge asking basic questions, she's already drowning. The court bends over backwards, reminding her, you'll have to follow all the same rules of evidence and procedure as a real lawyer. And she still says, yes, sir, I got this. Folks, this is like walking into a heavyweight boxing match with no gloves on. She never stood a chance. The prosecution starts strong. They put her probation officer on the stand, and let me tell you, it's bad news from the start. They lay it out plain as day. Ashley tested positive for methamphetamines. Not once, not twice, but enough that she even admitted in writing she'd been using. Then, when she was supposed to report to her officer, she just didn't show up.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her
stating that
UA
she-
was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No,
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
Up. On top of that, she gets arrested for a brand new crime and never even bothered to tell probation. Strike one, strike two, strike three. And she's still standing there like she's got some kind of ace up her sleeve. Now here's where it gets almost painful to watch. The judge turns to Ashley and says, "Do you want to cross-examine the officer? Do you have any evidence?" And what does she say? Absolutely nothing useful. No questions, no evidence, just nothing. Folks, it's like watching somebody walk themselves straight off a cliff. And you almost feel bad. But then you remember, she had a free lawyer sitting right there, coffee in hand, ready to work for her.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every month.
She sent him packing, and if you thought it couldn't get worse, oh, it does. Because Ashley finally opens her mouth and out comes the dreaded sovereign citizen script. Here's where the courtroom flips from sad to downright unbelievable. When it's Ashley's turn to speak, instead of giving any kind of defense, she launches into a full-blown sovereign citizen monologue. You know the type. There are no facts to dispute. The state is a fictitious plaintiff. No injured man or woman is present in court. Folks, I've heard some wild excuses in my time, but this one takes the cake. She's basically telling the judge the laws don't apply to her because, in her mind, the state doesn't exist. And then, as if that wasn't enough, she tries to twist it into some tax code nonsense. She claims this is a taxable event and that she just wants to be in compliance with the IRS. The judge's face says it all, pure disbelief mixed with exhaustion. He knows exactly what's going on. This woman is throwing out buzzwords. She found in some Facebook group, hoping the magic words will make her sentence disappear. Spoiler alert, they won't. The hammer drops. The judge goes line by line. Failed drug test, skipped probation meetings, ignored treatment, new criminal charges, didn't report police contact. He lays it out clear as day. Probation is a waste of time. And with that, he revokes her probation and orders her straight to jail. Case closed, right? Wrong, because Ashley, in her last act of delusion, declares she's owed $200 for every minute she spends behind bars. Yes, you heard that correctly. Not only does she not want to go to jail, she thinks she deserves to get paid for it. At this point, any shred of sympathy is gone. She endangered a child, abused drugs, blew her second chance, and now wants to play pretend lawyer while demanding a paycheck for being locked up. It's not just ridiculous, it's insulting to every parent, every taxpayer, and every person who actually takes responsibility for their actions. The judge doesn't entertain it for a second. Ashley Clark is taken into custody, and the courtroom moves on. But this disaster of a hearing will be remembered as yet another example of what happens when people choose fantasy over reality. So here's the takeaway, folks. Ashley Clark isn't some freedom fighter or misunderstood victim of the system. She's a probation violator who endangered her own child, tested positive for meth, ignored every single rule the court gave her, and then had the nerve to stand there and demand $200 a minute for being in jail. That's not courage. That's delusion. What really stings here is the missed opportunity. She had an attorney, free, ready, and willing to defend her. All she had to do was listen, accept help, and maybe, just maybe, the judge would have shown her some mercy. Instead, she fired her lawyer, read from a script she probably downloaded off the internet, and guaranteed the worst outcome possible. She didn't just lose her case, she embarrassed herself on the record for everyone to see. And that's the brutal truth about sovereign citizen nonsense. These people think magic words can erase reality. But when the judge slams that gavel, reality always wins. Ashley's not cashing in $100 a minute. She's cashing in every bad decision she's made. And in the end, the system isn't playing her game. She's playing by theirs, behind bars, where she put herself.